Good afternoon. I welcome all of you on behalf of Pusa Road CP Study Circle. Today we have a webinar on offences and prosecution under various acts, and especially on emphasis of role of chartered accountants. Our learned speaker, Advocate High Court, Supreme Court, KHEMKA ji is with us. He is by profession an advocate having chamber at High Court Delhi, in legal profession since last 30 years and having a very depth knowledge in criminal side, and he presented argued on behalf of big corporate clients to the High Court, Supreme Court, and argued a very wonderful matters, and on which the court has also decided given judgment which are very reportable landmark judgments. And he has also addressed Parliament Standing Committee on legal issues. This is his brief profile. I once again welcome sir and request, please sir, deliberate on the subject, sir. Thank you, sir.
Good evening, friends.
Good evening.
It is always a pleasure to speak to such august august people, a number of such august who belong to a profession like chartered accountancy. I have never considered myself separate from you people. I have always thought that chartered accountants and advocates, they are actually in one boat, and which is being proven by the learned people like Rajesh ji, Kohli ji, who have been surrendering the CP and are becoming advocates. So this shows that these two professions are so intermingled. They are, you need to kind of switch on and off in between these two professions. And because of that, I have very large number of chartered accountants. Some of them are my very close friends. Some of them are, they are my clients also. And I have done a lot of matters for chartered accountants personally, as well as referred by the chartered accountants in my profession. I have been always going and different forums of chartered accountants. I have been giving lectures on cross-examination, on drafting, and other things. But we have been doing matters, especially in the field of economic laws now. And I realized that once a client shifts, once a prosecution starts, or once there is a matter which relates with the prosecution, suddenly the chartered accountants think that it is nothing to do with them anymore. Now the lawyer will handle it. And this is widespread. And the proof of it came when I started speaking on this subject. And I went to Bombay, Chennai, Hyderabad, Thrissur, and so many platforms in Delhi. And whenever I asked the chartered accountants, sir, how many of you have read Chapter 22 of Income Tax Act? Most of the times in the gathering, there were very minuscule number of chartered accountants who raised their hands and said, yes, we have read it. So what to, this is one act which can be called Gita or Bible or Quran of the chartered accountants. And if there is one chapter in that, you are the masters of Income Tax Act. You are the masters of income tax law. And if there is one chapter in that law with which you think you are not concerned. I must put my foot down and say that, sir, it is a misnomer that this chapter also cannot be handled without you. It has to be, it is the baby of, it is your baby. It is it is another thing that a lawyer, a court where the prosecution is going on, it is something like your baby is going to hostel, but he remains your baby. You can't think that your baby has gone to the hostel and therefore now you are not concerned. Your baby has gone to the college. So the chartered accountants have to be conscious of the fact that none of these prosecutions, including under the Income Tax Act and other acts, which deal with fiscal matters, which deal with economics, which deal with commercial matters, they cannot be handled, my dear friends, without the active involvement of chartered accountants. After 1991, when a platonic shift came in the economy of this country, when the government decided to liberalize the economy, to change the ration quota Raj and make it liberalized. With liberalization, people started finding out new ways of breaking the laws and new ways of taking the benefit of leniency or the reformation or the liberalized economy, and they started taking the benefit of it. The result was that the government had to come out, the legislature had to come out with newer laws, be it Prevention of Money Laundering Act, be it Black Money Act, be it a whole new changed Companies Act, be it Benami Prohibition Act, be it IBC. So all these laws had to be brought in order to check those people who wanted to take the benefit of the liberalization. And all these acts contain provisions for prosecution in case of certain defaults. And to top it all, they are all interrelated. They are so interlinked that you cannot even separate them. In fact, I will give you, during my deliberation, I will give you examples where one simple act, which 40 years ago would have just gone as an income tax violation, that act, that one wrong has become subject matter of 4 or 5 different acts and prosecutions thereunder. So the situation is this, that we must know something, at least even if you don't want to practice it. The chartered accountants must have these provisions on the back of their mind when they are performing their jobs. I would say that whenever your client faces any such prosecution, you should be the one who should be the part of the team together with the prosecution lawyer. It should not be like that, oh, this was the stage till which I was concerned, and this is the stage with which I am not concerned. That attitude has to end now. The time has come when the chartered accountants and lawyers have to be proactive. Another problem which arises is that I have, with all humility at my command, I would say that the chartered accountants, over the period of time, because your clients are the clients who are your clients for decades together. A client comes to you year after year, you are his professional, you are his consultant. He actually becomes your family member very soon. When you work for him, you do not work with arm's length approach. And the result is that while working for the chartered, working for that client, you tend to expose your own skin, which is a very dangerous phenomenon. In fact, the cases which we are doing under PMLA, under other acts, we are seeing that a number of company secretaries and chartered accountants are co-accused. So the last thing I would want a professional brother of mine to be involved. If a client has done something, we should stop him from doing anything wrong. And we should also see to it that we are not caught on the wrong foot. Nobody is able to accuse us that we were party to that crime. We were party to that offense. So this becomes even more important now from that angle, that his own skin should never be exposed to any such situation. With these words, I would like to take you through, it is not possible to take you through all the provisions and to discuss all the provisions. I think a day will come in next few months of a year when I would be discussing finer points of the prosecutions under the criminal law and prosecutions under these acts. However, right now, what I take it as my duty is to take you through the main important provisions under which normally the prosecutions are launched. Is the screen visible?
Yes, sir.
Yeah.
Thank you, sir. Friends, this is chapter 22 of Income Tax Act. The chapter starts with 275A. It is very interesting to see that in this chapter, there is no section 275. Section 275 is actually part of chapter 21. And the chapter itself starts with chapter 275A. The first offense is contravention of an order made under subsection 1 or subsection under whoever contravenes any order referred to in second proviso to subsection 1 or subsection 3 of subsection 132 shall be punishable with rigorous imprisonment, which may extend to 2 years, and shall also be liable to fine. Now, you know section 132, you know what are the directions or orders given under, which can be given under subsection 1 and 3. So if a person is found not performing, not working as per the order, he can be punished with imprisonment up to 2 years. Now, the most important thing here is that this offense does not require any mens rea. You are well aware that mens rea is the most important thing. Mens rea, whenever we talk of criminal act, whenever we talk of prosecution, it is always said that one is actus reus and the second is the mens rea. Now, this particular section does not require mens rea. The mere act of contravention is enough for a person to be prosecuted. In fact, he can't give any explanations. There is nothing in this particular section which says that if there was any reasonable cause, there was anything. There is nothing here which allows him to do that. And strangely, it is not even, this particular section cannot even be compounded. It is now the new guidelines have come by the CBDT, under which this particular, the offense under this section is not even a compoundable offense. Although I would in all humility say that direction is constitutionally invalid, and it is beyond the scope of the powers bestowed under this act, and it contravenes the provisions of this very act, which I will take you through in a later part of my deliberations. Then said 275B, failure to comply with the provisions of clause 2B and subsection 1 of section 132. If a person who is required to afford the authorized officer the necessary facility to inspect the books of accounts or other documents as required under clause IIB. Now, a very recent judgment of our courts have come on this particular point. Now, what are these facilities? The facilities are, there is a computer. You are not providing the password of the computer. Now, this kind of things will come in my respectful submission within the definition of the facilities. And when we talk of this, the question arises whether a notice under 132 is prerequisite for initiation of action under 275B. Fortunately, in the very recent case, I mean not very recent, or 10 years ago, in the case of SR Bartley Boy and Company, the Supreme Court, the court has said, the Honorable High Court of Delhi has said that if notice under 132 is not given, 275B is yours. You cannot launch a prosecution under 275B. The facts there were that certain computers were seized from SR Bartley Boy and Company. The department wanted them to give the passwords for those computers, but the firm refused to give the passwords on the ground that computer contains the information about many of other clients, and it would be the breach of confidentiality. It will be the breach of privilege of confidentiality if we give you the password. Fortunately for the auditors, the court accepted this argument and said that in our considered opinion, the same privilege of confidentiality must extend to the auditors as well. In fact, they relied upon a Supreme Court judgment where the Supreme Court has said that the information stored in the bank must remain confidential. So the court said that if bank information with the banks should remain confidential, why should the information with the auditors of a third party of the clients be also not be confidential? So saying that, the court quashed any initiation of prosecution for under 275B. Then there is section 276, which says fraudulently removing, concealing, transferring, or delivering to any person any property or any interest therein, intending thereby to prevent that property or interest therein from being taken execution of a certificate. is punishable with 2 years of imprisonment and fine. Friends, now with the Benami law, section 53 of the Benami law, new Benami law, this almost similar thing has been made punishable with 7 years of imprisonment, where in order to prevent a property being taken in execution where for the payment of any tax or interest or government dues, then in that case, it is punishable with 7 years. In Income Tax Act in 276, it is punishable with only 2 years and fine. Now remember that under the new guidelines which have come in the month of June 2019 from CBDT, now all these three sections, 275A, 275B, and 276, have been made non-compoundable. I will, when I'll deal with the compounding part in a short while, I will tell you that why that notification, in my opinion, is not correct, and why it is against the express provision of this act. Now, this relates with the liquidator, so I'll just pass this. Then failure to pay tax to the credit of the central government, failure to pay TDS, failure to pay tax payable under 1150 or 194B, then the punishment can be up to 7 years and not less than 3 months. If you will see that again here, there is nothing like no mens rea there. It is the very fact of non-payment of tax. However, there is a saving grace that there is a section 278AA in this very chapter, which says that if a person can afford a reasonable cause, if he can afford a reasonable, like in one of the cases where all the books, etc., had been seized by the department, the court said that no, that there was a reason, there was enough cause with that person for not depositing that tax. Thus, identical punishment is provided in respect of when there is failure to pay tax collected under section 206C. Now the question arises whether delay in deposition of TDS also attracts prosecution. The Supreme Court says that yes, even a delay in payment of TDS is as good as failure to pay, and therefore the prosecution under 276B can be launched for such delay also. Now this is one section which is the most, in my opinion, the most important section of this chapter. Willful attempt to evade tax. Now this section, though it says, the heading says willful attempt to evade tax, but actually this particular section is two sections, two offenses, if I may say so, merged into one. Subsection 1 says willfully, I have highlighted in the different colors for your convenience. If a person willfully attempts in any manner whatsoever to evade any tax, penalty or interest. Now, there is subsection 2, which says if a person willfully attempts in any manner to evade the payment of any tax. I hope I've made myself clear. Subsection 1 deals with evasion of tax per se, while subsection 2 deals with the evasion of payment of tax, penalty or interest. Now, friends, question arises that there is an identity which in Black Money Act also now the new Black Money Act, with only difference is that while under 276C1, the punishment is up to 10 years, up to 7 years. Here the punishment is up to 10 years. There the minimum punishment is 3 months. Here the minimum punishment is 3 years. Then identical subsection 2 is also there, only with the difference that the punishment has been increased. There it is up to 2 years, here it is up to 3 years. The question arises whether the assessing officer has to wait till the completion of the assessment for initiating the prosecution under these sections. Friends, the answer is yes and no. The answer is that so far as subsection 1 is concerned, the prosecution can be proposed or initiated even before the completion of the assessment proceedings. However, in case of subsection 2, where it is default in payment of tax, it can only start after the assessment is complete and the tax, penalty or interest has become due. Now friends, this was the law till September 2019. Now, after on 9/9/2019, the CBDT has come out with a circular, whereby the CBDT has given an instruction that no prosecution under 276C1, that is for evasion of payment of evasion of tax, shall be processed till the matter of penalty has been finalized by the ITAT. So this law, which was there prior to 9/9/2000, all the prosecutions launched prior to 9/9/2019 will continue, even though they were launched even before the proceedings were not finalized by the ITAT. However, after 9/9/2019, no prosecution under subsection 1 for evasion of tax shall be launched unless the penalty proceedings have culminated till the stage of income tax appellate tribunal. However, so far as the subsection 2 is concerned, that is evasion to pay the tax. Now, let me ask myself, when would the stage of evasion to pay will arise? It can only arise that if either the tax has been self-assessed or there is an assessment order. So, as soon as there is an assessment order, and if the assessee does not get any stay at in the appellate court or appellate authority, then in that case, the prosecution can be launched against him for non-payment of evasion to pay the tax, penalty or interest. Then friends, failure to furnish returns of income. If a person willfully fails to furnish, now I just missed out on it. I'll just take you through these subsections again. And here you will see that there is an element of mens rea provided. It talks of willfully attempts or under reports. Subsection 2 also says willfully attempts. So that means that there is a scope where a person can say that this default by me was not willful, and these were the causes because of which I could not do it, or I made a mistake. So that scope of explaining is there. But I'll take you in the later part of my deliberations that all these all these mens reas, wherever they are provided in this chapter, the onus, unfortunately, is on the accused or the SSC. It is not on the department. The department has still to prove only the factum of actus reus, and thereafter the burden will shift, as so far as the mens rea is concerned, it will shift on the accused or the SSC. Now coming back to 276cc, if a person willfully fails to furnish in due time the return of fringe benefits, etc., I'm just giving a go by, or the return of income, which he is required to furnish under subsection 1 of section 139, or by notice given under clause I of subsection 1 of section 142, or section 148 or 153A, will be punishable if the tax evaded is more than 2.5 lakhs, with minimum imprisonment of 6 months and up to 7 years. This is the identical punishment which is provided under 276C(1). Because you may evade tax by two means. That is, one is by filing the return and not disclosing the income. Or the other way can be that you don't file the return as such. So in both cases, the offense is committed and the punishment of the same punishment is prescribed under the law. But the law makes exceptions to it. There's a proviso to this section, which says that there would be, so far as 115WD or section 139(1) are concerned, no such proceedings under this section could be commenced before for any assessment year prior to first day of April 1975, and for the assessment years commencing after 1/4/75 also, if the return is furnished by that person before the expiry of the assessment year, then also no prosecution proceedings will be initiated. And also, if after deducting the advance tax and the tax and TDS in his account, if the tax determined on regular assessment does not exceed 3,000 rupees, in that case also no prosecution is to be launched. The CBDT, by way of circular, the same circular which I was mentioning of 99/2019, has given directions that in cases in 276cc, the prosecutions should normally not be launched in cases where the tax evaded, tax penalty or interest are up to an amount of rupees 25 lakhs. However, if it is felt necessary to institute a prosecution under this section, even in those cases which are less than 25 lakhs, then a system of collegium has been created, and that collegium will decide, and that collegium's approval will be necessary before any proceedings can be launched. There is a similar section in Black Money Act, but the punishment for failure to furnish return. Now here the offense remains the same. However, what has differed here? The punishment remains the same, but what is different here is there is a general impression that unless the foreign asset or income is unexplainable, unless you have paid, if you have paid, suppose asset has been acquired by tax-paid money, by legal sources, then in that case, it is fine. But no, Section 49 and 50 of Black Money Act make it compulsory for any resident to declare if he held any asset located outside India or he was a beneficiary of such asset or had income from a source outside India, then in that case, he may have acquired it from legal sources. It may be an explainable asset. It may be an explainable income. But if he has not disclosed to the authorities here by way of filing of the return, it is punishable up to with imprisonment up to 7 years. And it will be minimum of 6 months. Friends, Section 49 of Black Money Act deals with failure to furnish return in respect of foreign income or asset, while Section 50 deals with failure willfully fails to furnish in such return. So you have furnished the return, but you have not disclosed the asset or income. Then in that case, it will be punished under Section 50 with the same punishment which is prescribed under Section 49. Then 276D, failure to produce accounts and documents. A person willfully fails to produce or cause to be produced on or before the date specified and in notice served on him under subsection 1 of Section 140. Such accounts and documents as are referred to in the notice of willfully to him under subsection, he shall be punishable with rigorous imprisonment up to 1 year. Now, there's a purpose that I have included this particular section in my presentation. Friends, we are doing a case for a chartered accountant where the information was sought from his client. However, as is the practice, the chartered accountants file replies on their letterheads, their own letterheads, under their signatures. So, this was done by the chartered accountant. And by mistake of the office, the documents which were to be annexed or along with the reply, they could not be done. The assessing officer issued a notice under 276D to my friend chartered accountant. Because unfortunately, in the reply which he submitted, he nowhere said that this reply is being furnished by me on behalf of the SSC under his instructions. So he, in a way, took it upon himself, the whole responsibility. And what the SSC did, the SSC told the IO, he gave a statement that I had given all the documents to my chartered accountant. Although I am very sure that I will be able to defend my friend chartered accountant from this. However, the question arises, and which in the beginning of my deliberation, I said that should this reply not have said that this is the reply I am filing on behalf of Mr. So-and-so. He has given me these informations. And also, even if you have to upload, even you have to electronically send these documents, these documents must contain the signatures of the client. You must get it signed, scan it, and file. Why should you take so much of responsibility on your shoulders, even for those mistakes, which may be by your office, which may be by the client? At times, the clients might like to save their skin. So why should it not be explicit in whatever you are saying, or whatever you are replying, or whatever is your pleading, or whatever are your submissions? Why should it not be explicit from that you are doing it only on behalf of your client under his specific instructions, and he agrees to the same. And in his agreement, he must sign all of them. All those signed copies should adorn your records. Friends, we have to develop a habit of working with an arm's length approach. This is my request to you as a friend, as a colleague, as a co-professional. False statement in verification. If a person makes a statement in verification under this act or rule made thereunder, or delivers an account or statement which is false and which he either knows or believes to be false or does not believe it to be true, again, the punishment is very, very severe. Friends, which verification are we talking of? To my mind, it is the verification of the returns. It is the verification in an affidavit. So filing an affidavit always contains a verification. So when an affidavit is being filed or when a return is being verified, you are verifying the correctness of the same. And if they are not found to be correct, then the prosecution can be launched under Section 277. It reminds me of a case which we are doing where a search took place. The SSC surrendered an income of about 5 crores. Simultaneously, he also gave an FD to the authorities, to the team, and said that this FDR should be enough for you to deduct all the tax and interest which is leviable on the surrender. The same was deducted. So the tax and interest stood paid on the surrendered income. A notice under 153A was received by the SSC for filing the returns. My friend, learned chartered accountant, went and on his own letterhead wrote that our return filed under Section 139(1) may kindly be treated as a return under 153A. The assessing officer imposed a penalty which was upheld till the Supreme Court. And the prosecution under Section 277 has been launched that if your return under 139(1) is taken to be the return under 153A, then the verification of that return is false. Apparently, on your admission itself. So something which was very much in our control was let go, and in this particular case. An identical provision exists in the Black Money Act also now. In fact, even the punishment is same. Then falsification of books of accounts is also a punishable offense. Abetment or inducement is also to avoid the tax, is also to be punished in the same manner as the evasion of tax. Then an identical provision exists in Black Money Act as well. Friends, the prosecutions under these sections are supposed to be only with the previous sanction of the principal commissioner or commissioner appeals or the appropriate authority. But as I told you that by way of a notification of 9/9/2019, the CBDT has come out with certain directions. It is trite law that whenever CBDT wants to relax the provisions of this act in favor of the assessor, it can be done. But can that be utilized for the change of the law itself? Here, it says that the prosecutions will be sanctioned by a principal commissioner or CIT. But by way of that notification, the CBDT now says that in cases where the tax liability is less than 25 lakhs, there would be a system of collegium where the two CCITs or two CITs or two principal commissioners, etc., would form that collegium, and only then the prosecution shall be launched. There is an identical section in Black Money Act. Now a question arises whether show cause notice is a must before initiation of prosecution or grant of sanction. Friends, it has been answered by the Supreme Court that no show cause notice is required by law before grant of sanction. However, as a practice, the department has been invariably issuing notices prior to the grant of sanction. राजेश जी कुछ कहना चाह रहे हैं?
I don't think so.
No, sir, no, nothing, sir. Please continue.
Okay. Now, friends, a lot of time I have been told that what is the necessity of answering this notice? Or why should we disclose our defense at this stage to the department? Friends, with all due respect, I would submit that there should not be any straitjacket formula for handling the notices. When a notice, in my opinion, even when the penalty proceedings start for evasion of tax, at that stage also, it is not harmful to consult a prosecution lawyer who deals with in this particular field. However, according to me, the stage of replying the notice before the grant of sanction is the last stage whereafter at which you must engage a lawyer and formulate a team. Engaging a prosecution lawyer should not mean that you detach yourself or you just refer the matter to a prosecution lawyer. You are the master of this case. Without you, it is almost impossible to do this case. However, since you do not understand the intricacies of the criminal law, you need the help and association of an income tax lawyer. So, form a team. My answer to how the reply should be given would be that you must, because the onus to prove the mens rea is on you. In fact, even your reply to in the penalty proceedings should be such where you should be able to explain the mens rea part at least. And here also, that explanation should be there. And in my opinion, in almost in every case, there is no harm in disclosing the defense. Sometimes you may have one or two issues or one or two facts which you may like to hold back for the prosecution stage. But it is always better to give an effective reply so that maybe the sanctioning authority will drop the proceedings, or if the sanctioning authority does not drop the proceedings, then in that case, you may be able to get the benefit of it at the time of trial, where I would be able to say that, look, this is what was said in my reply. This is what was the reply given to you. You did not apply your mind to the contentions raised by me, to the facts pointed out by me, and therefore my prosecution is, the sanction is bad, and therefore my prosecution is liable to be dropped. So friends, this is how I would say the approach for replying to this show cause notice will be. Then 279(2) says that any offense under this chapter may, either before or after the institution of the proceedings, be compounded by the principal chief commissioner or principal director. Friends, if you see the language, it says any offense under this chapter. I told you that 275A, 275B, 276, these three sections, the offenses today, as the situation stands, as the fresh directions of CBDT given on 14/6/2019 say that these three offenses cannot be compounded. I feel that those directions are in violation of this particular section. Let an appropriate case come when we might be able to challenge this provision. Then it also says either before or after the institution of the proceedings. Now, after this, one can understand that even at the stage where I have been given a show cause notice, or I realize that this particular wrong of mine might result in prosecution, I can always go for prosecution. However, what is the meaning of the words after the institution of the proceedings? Now, after the institution of proceedings would obviously mean till the end of the proceedings, and which was always the practice. Very frankly, we would wait till the end of the evidence. And once we realize that no, even after we have not been able to take out much in cross-examination, and the conviction may be unavoidable, we would at the fag end of the trial go and apply for compounding. The law allows us to do that. However, by way of the instructions issued on 14/6/2019, the CBDT has come out with a limitation period. And the limitation is also very very strange, if I may say so. It says that the application for compounding can only be filed within 12 months of the end of the month in which the prosecution complaint was filed with the special court. Now look at the situation where a complaint is filed. The judge is on leave, a date is fixed, or for some other reason, the lawyers are on strike, or any other reason can be there. And a notice is also not issued to me or is not received by me for next 12 months. My opportunity to file for compounding is taken away. And in any case, this is against the provisions of this act. That as a one-time measure, that limitation was extended up to 31st January 2020. However, thereafter, the law stands as amended. I'll just skip that. Now, I've already discussed the part that prosecution and penalty proceedings could go on simultaneously. However, what is the impact of each other on, of the outcome of each other? Whether the prosecution can be initiated before the conclusion of the penalty proceedings, the answer is yes, it can be initiated. As I have already told you. If the penalty proceedings fail, can the prosecution continue? The answer is again yes and no. If the prosecution, if the proceedings, adjudication proceedings fail on technical grounds, then in that case, they do not affect the prosecution. But if it is on merits, then in that case, the prosecution must be dropped. So this is been held in the celebrated case of Radheshyam Kejriwal versus State of West Bengal. They have described the whole law on the issue. If no, that's a very academic question, that if no penalty proceedings are initiated, can the prosecution be launched? The answer is yes. Now coming to the offences under the Prevention of Money Laundering Act, let me just quickly take you through the definition of what is money laundering. Whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with proceeds of crime, including its concealment, possession, acquisition or use, and rejecting or claiming it as untainted property, shall be guilty of offence of money laundering. Now, this conjunctive end, that apart from the fact that there should be a crime which is a part of the scheduled offence, there should be generation of proceeds of crime, and those proceeds of crime, the person should have projected or claimed it as untainted property, shall alone be guilty of offence of money laundering. This end was very important, that you can only call it money laundering after the person tries to launder it. However, in a very recent amendment, the legislature has amended this section and added this explanation. For removal of doubts, it is clarified that a person shall be guilty of offence of money laundering if such person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more of the following processes. Now, if you can see that it says concealment, possession, acquisition, use, or projecting as tainted property, or claiming as untainted property, friends, that conjunctive and the legislature now says that we want to treat it as or. It should be treated as or. One would ask why, if they wanted to change it, they could have amended the section itself. But the problem was that there are thousands and thousands of cases which are going. Just upon the amendment, the legislature now wants to say that we never had the intention to use the word and. Although this has created a very precarious position that even as soon as a scheduled crime is committed and the money is generated, the offense of money laundering is also committed. So this is a very precarious condition and this is a very precarious situation. This was the judgment which has prompted the legislature to come out with, because it very clearly said, the Gujarat High Court judgment, it clearly said that conjunctive and was there and it was necessary that someone should have projected or claimed it as untainted property. But the situation may be a little different after the amendment. Now, coming to the issue, is there or can there be any relationship between offences under PMLA and offences under the Income Tax Act? Friends, we all know that in the schedule of Prevention of Money Laundering Act, none of the offences under the Income Tax Act is a part. It is no offence under the Income Tax Act is a scheduled offence under the Prevention of Money Laundering Act. Still, I would like to say that we cannot be oblivious that there are repercussions of the income tax violations which can be or directly or indirectly be brought under the PMLA. I'll just show you how. Offences under Section 51 of Black Money Act. Now, Section 51 of Black Money Act is the scheduled offence. Then any fraudulent act may attract sections 417 to 420 IPC or Section 447 of Companies Act. Now, 447 is a scheduled offence, 417 to 420 of the IPC are also the scheduled offences. I will give you an example. There is a private bank. In that private bank, certain directors, by way of fraudulent transactions, siphoned off certain money. So the offence allegedly under Section 447 of Companies Act was alleged to have been committed, and the Serious Frauds Investigation Office, that is the SFIO, the part of the Ministry of Corporate Affairs, came into the picture and has investigated and filed a complaint under 447 of Companies Act for fraudulent transactions under that act. Now, friends, that money which those directors earned by fraudulent means or by fraudulent transactions, they utilize the services of a person who happened to be a chartered accountant for getting the accommodation entries, and by using those accommodation entries, they invested that money in certain properties. The chartered accountant routed that money through many of his companies, which were in the names of, where the directors were his employees or his associates or his drivers, PNs, etc., etc., for the purpose of providing accommodation entry. So the charge is that he is an abetter to the offense under 447. And therefore, he is also a co-accused in that complaint. Since the money which was earned by way of fraudulent transactions under 447 was channelized in this manner, Therefore, there is an attempt. This is an offense under the PMLA as well. You understand that it is an offense under the Income Tax Act. And since the chartered accountant utilized so many companies which were not his as Benami companies, so he will also be, we may also be liable to prosecution under the Benami Prohibition Act also. So you see that, as I said in the beginning of my deliberation, that these offenses or these wrongs are not standalone wrongs. Then friends, 467, 471, 472 of IPC, which deal with false and forged documents, are also scheduled offenses. And I'll just like to take you back in my deliberation to section 276C, which explains where the proviso to 276C1 explains willful attempt to evade tax. What is willful attempt to evade tax for the purpose of that section shall be? It is where a person has in his control or possession any documents or books containing false entries, or makes or causes false entries in the books or documents, or omits or causes to be omitted any relevant entry, apart from the penalty which might be imposed under the new 271 AAD. He has also committed an offense of forgery, my friends, which is a scheduled offense. And that is why I'll take you to the definition of forgery in IPC, just to show you how whatever are the requirements of 276C1 are also the ingredients of 463 of which is forgery. Whoever makes any false document, false electronic record, or part of any document or with intent to cause damage or injury to the public or to any person, or to support any claim or title, or to cause any person to part with the property, or to enter into any express or implied contract, or with intent to commit fraud, or that fraud may be committed, commits forgery. So the false entries in the books, in the documents, with the intention to evade tax is the requirement, are the ingredients of 276C1, and they are also the requirements of forgery. They are also the ingredients of forgery. And once a document, a forged document, whoever fraudulently or dishonestly uses as genuine any document or electronic record which he knows or has reason to believe to be a forged document or electronic record shall be punished in the same manner as if he had forged such document or electronic record. And 471, my friends, is a scheduled offense. So it is only a question of, department does not normally, file complaints read with the IPC offenses, because probably they don't want to work hard, or probably they don't know the law, or whatever. But the day may not be far when these innocuously looking income tax violations may be covered under the IPC, or may be prosecuted under the IPC, and resultantly under the money laundering PMLA as well. Now, friends, always it comes to mind as to upon whom the burden to prove is. Now, this Magna Carta judgment of Sharad Birsan Shah versus State of Maharashtra was given in the year, in the same month and year in which I joined the profession. And it said that the prosecution must stand or fall on its own legs, and it cannot derive any law has review law.
Please mute your phones.
जस्ट ए मिनट भाई साहब, 1 मिनट रुकूंगा। जी सर, जी सर।
Yes. Now, however, this trite law has gone for a toss under the new legislations, especially dealing with economic laws and laws dealing with the terrorist and activities or acts against the state. Now, Section 24 of Prevention of Money Laundering Act says, casts a reverse burden. In any proceedings relating to proceeds of crime under this Act, in the case of a person charged with the offense of money laundering under Section 3, the authority of the court shall, unless the contrary is proved, presume that such proceeds of crime are involved in money laundering. So, a very simple reading of this section is that there are two parts of what has to be proved. Number one, a scheduled offense has been committed that the ED will prove. That scheduled offense generated proceeds of crime, the ED will prove. Those very proceeds of crime are the subject matter of the offense here, ED will have to prove. However, what was the presumption? Such proceeds of crime are involved in money laundering. Now that involved in money laundering, the act of money laundering claiming or projecting them as untainted money is no more there after the amendment. So after this new amendment, this particular section may actually become redundant because there is no question of the act of money laundering here. Even the simple crime has become money laundering. So how the courts actually synchronize them is a question which is yet to be seen because these amendments have just come a few months ago. Friends, in the Black Money Act as well as in Income Tax Act, as I was taking you through the provisions of Income Tax Act prosecutions, I was continuously showing you that there are offenses where there is no culpable mental state is required. However, there are offenses where the willful words willfully, fraudulently, knowingly, all these are there, which require a culpable mental state of the mens rea, as we say. However, this particular section imposes a reverse burden on the assessor. The department is not to prove that there existed any such mental state. However, it is for the defense, it is for the accused to prove that he had no such mental state with respect to the acts charged as an offense in that prosecution. Unfortunately, this particular section, which on the face of it looks like a very, very draconian kind of a section, because you are imposing penalty on the person, you are charging interest, you are taking tax, and on the same facts, and on the same facts you want to prosecute him as well, without even showing that there is a mens rea involved. The constitutional validity of this section was challenged in the case of Selvi Jayalalitha in the Madras High Court. And in a very strange judgment, Madras High Court said that since this particular provision has stood on the statute book for so long, so this would be a presumption in favor of its constitutionality. I'm unable to understand how does that become a ground for upholding the constitutionality of a section. An impression comes to the mind that whenever there is a reverse burden, as if everything has to be proven by the accused only. However, in a recent judgment in 2018, the Supreme Court has said that it cannot be understood to mean that the moment an allegation is made and the FIR recites compliance with the statutory procedures leading to the recovery, the burden of proof from the very inception will uh, will will shift uh, from the accused without the prosecution having to establish or prove anything. So that is a saving grace. Then there is a provision in the Income Tax Act which says proof of entries and records of documents. This is a standalone provision which never existed in any other law and which goes uh, tangentially against the provisions of Evidence Act and evidence, the basic principles of evidence, that the document should be proved only by the originals. Here, the law allows the authorities to produce only copies that just attested by the authorities. A similar provision has now also been brought in the Benami Prohibition Act. I think Rajeshji, I should. How much time do I have?
नहीं sir, as the members like, if you want to conclude, take the queries.
I think I'll just take 5 minutes and then take queries, right?
Okay sir, okay sir.
So I am just quickly taking you through the offenses under the Benami Transactions Act. I'm not taking you in the definition of Benami transactions, etc., which I know you have benefit of Ashwini Taneja ji and other people on that subject who are the pillars of this subject today in the country. However, I'm just taking you to the prosecution part of it. So Section 3 of the PBPT Act, which has existed since 1988, said in its subsection 3 earlier, now which is subsection 1 as subsection 2 has been deleted, has been repealed. Now it says whoever enters into any Benami transaction shall be punishable with imprisonment for a term which may extend to 3 years or with fine or with both. So, and I will also read the next section. Whoever enters into a Benami transaction on or after the date of commencement of Benami Transactions Prohibition Amendment Act shall, notwithstanding anything contained in subsection 2, shall be punishable in accordance with the provisions contained in chapter 7. So, any offense of Benami transaction after 1/11/2016 will be as per chapter 7. So only the offenses prior to 1/11/2016 are to be governed by subsection 2 now. Section 3, subsection 2. And the incidence or the cause of action for the launch of prosecution is entering into the Benami transaction. So the cause of action will arise on the date the Benami transaction was entered into. While if you go by the definition of Benami transaction, even holding a property Benami or the transaction might have been entered into at any time in past. However, if the property exists, now that property can be attacked. But prosecution cannot be launched. Prosecution can only be launched with effect for prosecution, the cause of action will arise on the date the Benami transaction was entered into. Now, this particular subsection provides for a punishment of maximum punishment of 3 years. Section 468 of CRPC provides for limitation in such case. It says that the limitation for launching the prosecution in such cases would be 3 years, which means that as on 1/11/2019, the limitation for launching the prosecution ended. So whatever prosecution, in most cases, I think no prosecutions have been launched so far as 1/11/2019, prior to 2019 are concerned. So far as the offenses where the Benami transaction has been entered into after 1/11/2016 is dealt with by chapter 7. There, while you see in chapter subsection 2, there are no factors. The mere Benami transaction, entering into the Benami transaction was punishable. However, now the situation is not so. Not all Benami transactions can be subject matters of prosecution. Where any person enters into a Benami transaction, in order to, there are three situations: to defeat the provisions of any law, or to avoid payment of statutory dues, or to avoid payment to creditors. So the first situation is where the purpose of entering into a Benami transaction is to defeat the provisions of any law. For example, there are land reform laws almost all over the country, where the people of certain castes or classes cannot sell property to anyone outside that caste or class. Now, there are many ingenious methods adopted by people for that purpose. One of them is buying it Benami in the name of somebody who is from that caste or class. Now, that transaction would be the one which will be subject matter of prosecution under this section. Similarly, if it is meant to avoid payment of statutory dues, if you recollect, I had shown you 276 Income Tax Act, which was punishable with 2 years of imprisonment for avoiding the payment of statutory dues. But if you use a Benami transaction for the payment, for avoidance of payment of statutory dues, then the punishment could be up to 7 years with minimum punishment of 1 year, or to avoid payment of creditors. Now, if a suit is going on, or if a case is going on against a person, or if he knows that a liability is about to come on me and he transfers his property to somebody, Benami, in order to avoid payment of creditors, then also it is liable for punishment, prosecution. Who can be punished? Beneficial owner and Benamidar, of course, but any person who abets or induces in any manner can also be punished with a similar intensity. There can be fine also, there shall also be a fine which may extend to 25% of the fair market value of the property. Then friends, penalty has also been prescribed for giving false information under Section 54 of PBPT Act, for which the punishment can be up to 5 years and minimum punishment of 6 months, with fine which may extend 10% of the fair market value of the property. Recently, Section 54A has been added in PBPT Act, where if a person refuses to cooperate with the summons issued to him by the initiating officer, then in that case, the punishment is 25,000 rupees for each of this default. Prosecution in this section again cannot be launched without the sanction of the board. Now, after the amendment, it is a competent authority which has been defined as certain officers of senior officers of income tax department only. Earlier, it was the CBDT, which was to grant the prosecution. Now, just let me give you in 2 minutes the procedural part. All prosecutions under PMLA, PBPT, as well as Income Tax Act have to commence with a complaint before respective special courts. All these acts provide for special courts, and the prosecution has to be initiated by way of a complaint under Section 190 of CRPC. Then provisions of Criminal Procedure Code are applicable to all these proceedings as for these sections. Section 65 of PMLA, PBPT, Income Tax Act, Black Money Act. In the normal course, when a complaint is filed, the complainant has to be examined by the magistrate on oath. However, Section 200 provides for an exception in the case of public servants, that the magistrate need not examine them on oath, and the summons can be straight away issued. So since all the complainants under these acts are public servants, the summons are normally issued without examining them on oath first. Then section 204 says that no warrant should be issued unless there is a list of witnesses attached with the complaint. Every summons should be accompanied by copy of such complaint. So section 204 read 207 of Criminal Procedure Code authorizes the accused to have the copy of such complaint together with all the documents. So when the summons are issued, summons are received by such a person, he is not in a position to know as to what he is getting and how much, whether the set is complete or not. So, and his phone normally comes to you that I have received the summon, what to do. So please advise him to write on the, while receiving the summon or the warrants, that how many papers he is receiving or he is not receiving. He must write that received the summons without any annexures, without any copies. So that is one care which has to be taken. Now, another thing is when we receive a summon, it's a very cryptic language of that summon. It's a very deceptive one. So people think that someone has come from the court, I can go straight away to the court, but no. Even in the offenses which are bailable, you have to go with a surety to the court. The accused should not go like this, because the court will ask him for furnishing a bail bond. Even if the offense is bailable, even if the offense is only the summons have been received, not the warrants have been received, then also he has to furnish the summons, and he must make proper inquiry as to what are the, in the normal course, how much security the judge is asking for, what are the documents required for it, and all those things have to be taken, and you have to be ready for that. Accused has to be present on each and every date of hearing. However, the magistrate may dispense with the personal appearance of the accused, which is not dispensed in a normal circumstances. There have to be something extraordinary circumstances where the personal appearance of the accused is dispensed with. This is also, after you receive the summon, we have to be a little proactive. We have to decide whether we have to challenge the summoning order, we have to, whether summoning is proper, whether sanctioning is proper, whether legal requirements under all these acts have been complied with or not. So this is the stage where we have to act very fast. We have to decide what action has to be taken. Whether we have to file a revision, we have to file questioning, we have to wait till the formation of the charge, etc., etc. So this is what I wanted to share with you. Thank you so much for your patient hearing. Now let me just come back to you and stop sharing. Now, any questions, if any one of you have, I would love to answer.
Sir, queries are available in chat box.
Okay.
If you read it, or should I read?
No, I'll read it. From 359, Namaskar, great initiative. Rajesh ji, Dinesh webinar are also alternate day. Please avoid time illusion.
Or next, hello, sir, next.
Okay.
First question from Sumit Saurabh ji.
Sorry. Whether a person got prosecuted on the matter of non-payment of tax, penalty, etc., will he get immune to pay such tax or penalty further in any manner, if possible? No, sir. Frankly, these are two. I said that these are two independent proceedings, and I cited the judgment for that also. So these are two separate proceedings. He's liable for penalty and interest. Simultaneously, he is also liable to be prosecuted for any such violation. Then filing of false tax audit report and penalty thereof. So please advise. So if a person has filed false tax audit report, that is exactly the case which comes in the category of abetment. If the audit report itself is false, then in that case, he is abetting the person for creating the false documents or false um, papers for the purpose of evasion of tax. So it is clearly a case where not only the SSC will be prosecuted, but also the auditor, it may come on the auditor as well. If a person had filed ITR manually in paper mode, which otherwise was required to be filed online, will the ITR shall be treated as non-filed and penalty for non-filing shall be levied. In fact, you should guide me on this, that can it be called filing of the ITR? Can it be called filing of the return, Rajeshji?
I think
If it has been filed in the manual mode, which was supposed to be filed online, it cannot be, I suppose.
it cannot be.
It is not. It is
cannot be.
as good as ITR not filed.
It is as good as ITR not filed.
Not filed.
As a matter of fact, sir, if it is a wrong form also, then it is also ITR not filed.
Exactly. So it is ITR not filed, and the prosecution for non-filing of the return can be launched.
But in the meanwhile, the SSC can plead and take
Yes.
alternatively request for filing of the online.
Yes. This
Remove the defect.
this could be a valid defense for him. In the prosecution, this could actually be a valid defense that, look, I was not aware of the online procedure and therefore I mistakenly filed it. So he may not be convicted on this ground. But prosecution can be launched against him. Could you elaborate differentiation between situations when summons or warrants be issued under the PMLA? See, PMLA out of all these acts is the only act where the authorities, the ED has the power to arrest. Now that is a totally different subject because they can arrest a person. Now your question is that can you differentiate between the situations where warrants should be issued or summons should be issued?
Correct.
Now, whenever the magistrate has a feeling or magistrate has any material on record to think that this person is likely to run away from the clutches of law, he may not come back, he is likely to interfere with the investigation, he is likely to interfere or influence the witnesses, or is likely to take away any documents or anything. In that situation, the magistrate will exercise the jurisdiction to issue the summons or issue the warrants. Otherwise, in the normal course, it is the summons which are issued, and the magistrate has to give the finding, has to give reasons for issuance of those warrants. If he is choosing to issue the warrants, this is what the CRPC says.
Sir, in respect of the economic offences, is
Yes.
that the generally, normally the warrants are issued, or even summons are also issued?
Normally the summons are issued. I told you that if there are additional circumstances where a person is, suppose the person is likely to run away from the country, then the court, if the authorities tell the court that, sir, he's about to run away from the country if you don't issue a warrant, so then the warrant will be issued. If suppose,
that is the ED will bring this to the knowledge of the magistrate.
Exactly. Authority, ED can arrest.
And it will,
ED
and it will be put on record.
No, ED has the power to arrest himself. So officers of the ED, they can arrest themselves. They need not come to the court for issuance of warrants. They have the power to arrest themselves. However, in all other acts, whether it is the Income Tax Act or it is Benami or it is black money or any other act where the economic offences are there, the power to arrest is not there. So in that case where the power to arrest is not there, the officer has to come to the magistrate seek the warrants and then arrest that person.
Can the accused contest that why arrest or warrants have been issued?
Yes.
Even the summons was
Yes,
good
yes,
enough.
yes.
I have got an order in one of such cases where the warrant was issued without giving any reasons. I went to the court and court said that yes, the court before issuance of warrants must give reasons as to why the warrants are being issued.
And they should be recorded, those
They
reasons.
should be recorded, yes. They have to be recorded in writing. That is what the law says. That is what CRPC says.
Next, sir, next.
Yes. In Benami law, the property involved will be confiscated, and whether the 25% penalty of the value of the property is over and above the property confiscated. Absolutely
Yes, yes,
Absolutely.
yes.
In proceedings relating to foreign bank accounts are pending with Delhi court, is it compoundable? Sir, no proceedings under Black Money Act are compoundable. Proceedings only under the Income Tax Act are compoundable. And that too, I told you, 3 of the sections under the Act have been made non-compoundable by executive orders of CBDT, which is against the law as per me. However, so far as Black Money Act prosecutions are concerned, there is no provision for compounding.
I think there is no queries left now. Now over to Kohli sir.
Let Dhamija do it, sir.
Okay, over to Dhamija ji sir.
मैं कर दूंगा, मेरे को दिक्कत नहीं है, बैठे सर.
Dhamija sir.
I have many thanks to KHEMKA ji for really educating us the basic provisions of offences and prosecutions under various different acts, and vis-a-vis the liability of the professional chartered accountants. We, when work in so much of the close environment with the client, then we forget that there could be, it can lead to some kind of problems for the chartered or professional. So I hope he shall continue to exist in future also, and minor of these very different acts. I once again thank him a lot for his sparing his valuable time. Thank you very much. Over to Rajesh.
Thank you, sir. Thank you. Thank you once again.
Thank you very much.
And everyone. Thank you, KHEMKA ji, sir. Thank you.
Thank you very much, sir.
Meet you tomorrow at 4 p.m.
Thank you, sir.
Goodbye.
Okay.
Goodbye, sir.